Hello, everyone, and thank you so much for joining our WAITS webinar. It's What Are the Experts Saying? Today we'll be discussing the SEC's ALJs and the latest constitutionality and enforcement issues. I wanted to welcome again everyone. Thank you so much for your time and being here. My name is Jenna Ellis, and I am one of the moderators today. And our other moderator is Dan Titello. He's my colleague, also legal training consultant. And if you have any questions during this webinar, or if you want to pose a question to Mark, our expert, please feel free to do so. Just drop down the chat feature at the top of your screen, and then use the drop down to select Dan Titello and chat directly to him. And at the end of our webinar, we'll take questions from you. So that's a great way to get a question to Mark. So with that, I would like to welcome Mark Nelson. Mark is a writer-analyst with Wolters Kluwer, and he is also a contributor to Securities Regulation Daily. And he also contributes to SEC Filings Insight and also, of course, to the Federal Securities Law Reporter. So thank you so much, Mark, for being here.
Oh, thank you, Jenna.
Sure. So we're going to get in, and we have kind of an overview that we'll talk about. We're going to, of course, introduce the topic, and we'll talk about some of the big factors in the cases that have been brought lately. And the first one is going to be jurisdictional issues. And then we'll move to merit issues and, of course, some bias allegations that people have been reading about. We'll then move to some of the potential remedies that have been presented. And then we'll talk about what should we look for. If you're dealing with this issue, what do you need to know looking forward? So those are the topics, and that's how this webinar will be set up. But prior to that, Mark, you mentioned some kind of some breaking news, if you will, with this issue. And I think there's two subjects that just happened. Do you want to talk about those first?
Just in the last week, one of the things that happened is the SEC issued twin rule proposals to, as they say, modernize their rules of practice for administrative proceedings. Just having taken kind of a quick look at them, it looks like this would probably lengthen the process, maybe by a few months, 2 to 4 months perhaps, and it would allow for parties and respondents to take depositions. I did glance at the economic analysis. It looks like in addition to lengthening the process, it would probably have some additional costs. The SEC, at least at the proposal stage, is talking about deposition costs of about $36,000 for one deposition, and perhaps as much as $500,000 for one matter. So I think, in the coming months when the public begins to submit comments on these, that's something to look at with those two proposals, is whether this does not, if this is enough of a step in the right direction, whether the costs are justified, and I think we'll see some comments on that probably before the end of the year. The other development is something that happened just yesterday. The D.C. Circuit Court in Jarkessi versus SEC issued an opinion. This is not really an Article 2 Appointments Clause case like the cases we'll talk about today. It raises some different constitutional issues as well as some discovery type issues like Maryland versus Brady issues. But the D.C. Circuit panel focused almost exclusively on the very same jurisdictional issues we'll talk about today. So if you haven't taken a look at that case, I would recommend taking a quick look at it, just to get the latest view from one of the federal appeals courts on this matter.
Okay, great. And I think it seems like things are happening, weekly or daily with these issues. And I know Jarkessi looks at jurisdictional issues. And we'll, like you said, we'll get to that. But before we do, I just wanted to kind of start the webinar with the basics, because I think Dodd-Frank really has a role with all these kind of new controversies.
That's right. The general fairness issues about agency proceedings that the parties suing the SEC have raised, those really are not new issues. Everyone has been worried about the compressed time frame, the lack of discovery tools and other evidentiary protections that would be available in federal courts being absent in the agency proceedings. But I think what's probably kind of pushing these ALJ cases along now is a change that the Dodd-Frank Act made back in 2010. As many of you know, Section 929P of the Reform Act altered the securities laws to give the Commission a choice of pursuing civil penalties against unregistered persons in either an agency proceeding or in the federal district courts. And I think this is one of those things, it just adds to the general unfairness concerns that people have had for many years, and has certainly motivated a small group of respondents in SEC proceedings to take the matter into the federal courts and try to get a different kind of result. It also kind of invokes, some of the issues raised by Justice Breyer in his dissent in the Free Enterprise case involving the Public Company Accounting Oversight Board, also from 2010. That's a case that is just omnipresent in the SEC ALJ cases, and Justice Breyer raised the prospect, what of all these 1,500 or 1,600 ALJs across federal agencies, and what might become of them? I think the majority in Free Enterprise kind of cautioned against seeing its decision there as a broad-based decision against the civil service among the federal government agencies, but it also did leave open the question of where do administrative law judges stand under Article 2. So these are a lot of the questions that are raised in the cases challenging the SEC, and it's something definitely to look for future developments on as we go along.
So when we look at these jurisdictional issues, and you started talking about the free enterprise, we have a slide up here that has 4 different cases, and I think 2 of them are cases that the challengers really like. They like the facts of those cases, and then conveniently 2 of the others are the SEC and what they counter. Is that right, Mark?
Yes, that is correct. Yeah, as a general rule, all 4 cases stand for the proposition that when Congress makes its intention to channel cases through the agency process first, fairly discernible, then with few exceptions, those cases need to be heard by the agency, and then if there is an adverse ruling against the respondent could then petition a federal appellate court to review the agency's decision, and it's essentially what the channeling statute applicable to the SEC says in most cases. The 4 cases on screen here, they also talk about several factors which the challengers against the SEC like because they might salvage district court jurisdiction in some instances. It's unclear whether that will happen in these cases. But things like
the challengers like the top 2 cases, right? Sorry,
they do like the top 2
cases, right?
Yeah, the challengers definitely like Free Enterprise and McNary. Those are cases where I think some of the factors that I was going to mention also come into play. In Free Enterprise, we had plaintiffs who were challenging the very existence of the PCAOB rather than a specific sanction or any of the PCAOB's auditing standards. In McNary, that was a challenge to the immigration reform laws in the 1980s, which had created a twin amnesty program. In Free Enterprise, the Supreme Court said, basically, you don't have to bet the farm to get the attention of federal courts. And, this was, the issue about the PCAOB's existence, which was predicated on the so-called dual for-cause removal violation under Article 2 of the Constitution, was the kind of thing where channeling the case through the agency first would result in no meaningful judicial review. It was really collateral to any. There was no proceeding, so it was truly wholly collateral to the agency's process, and it was something that was likely beyond the agency's expertise to decide. And so the government lost that case. In McNary, you had a much more complicated statutory scheme And as one of the court's holdings, they interpreted the scheme to mean that individual cases were intended to be channeled through the agency first, but that the broader process and practice procedure type claims that the immigrants there had made were not really intended by Congress to go to the agency first. And again, this was a case where, the immigrants were really being asked to bet the farm, much as in free enterprise, the immigrants would have had to surrender themselves for deportation and voluntarily, subject themselves to a rather draconian remedy in order to get into federal court.
So what about the other side? What is the SEC? What cases are they using?
Yeah, on the other side, the SEC really likes the Supreme Court's decisions in Elgin, which is its most recent pronouncement in this area, and they also like the Thunder Basin decision. These are ones where the court said the cases needed to be channeled through the agency first, and especially in Elgin, the court there really didn't see a role for some of the factors that the challengers might rely on, such as whether there's meaningful judicial review, whether things are wholly collateral, or there's agency expertise here, and instead said, the statute was pretty clear about how things needed to proceed before the agency. Which brings me to one of really the only appellate decision we have so far in the SEC ALJ cases, and that's the one from the Seventh Circuit in Lori Bebo versus the SEC. This was a case that was actually argued before the Seventh Circuit while Lori Bebo's administrative hearing was in progress, as one of the reasons her counsel wanted to speed up the Seventh Circuit's decision if they could. What that court did was to affirm a district court ruling that there was no district court subject matter jurisdiction. But the court also went on to say some other things. It said, as its main holding, that the statute was pretty clear. Exchange Act 25 required the types of claims that Bebo was making to go to the agency first, and that she could achieve meaningful judicial review later on if the commission ruled against her by petitioning for review in either the D.C. Circuit Court or the Seventh Circuit. One of the other more interesting things the court did in the Bebo decision, however, was to kind of dissect one of the factors that courts may look to, and that's the wholly collateral factor. A lot of courts will just kind of look at whether the constitutional claims and the administrative action are highly intertwined with each other. And what the Seventh Circuit said is that there's really two diverging lines of argument here. One is something that the challengers like to do against the SEC, and that's to look at the free enterprise decision and to kind of compare the constitutional claims to the facts that undergird the administrative case against them. Another way to look at it, which is the tack that the Seventh Circuit took, is to look more closely at the Supreme Court's Elgin decision and just ask, are the constitutional claims in district court being brought, just for the purpose of upending the agency action? Another way to look at this issue is really presented by the Tilton case out of the Southern District of New York, where the trial judge there said, the wholly collateral issue was kind of a close call because the questions involved are not those that are routinely heard by an agency like the SEC, but just as the Seventh Circuit in Bebo said, the district court in Tilton said that she was not the kind of person who would have to bet the farm to get meaningful judicial review. That the Bebo and Tilton cases could go through the SEC first. As for that last prong, the agency expertise prong, we've seen, it's one of those that can go either way. The challengers, of course, will argue that the agency lacks expertise to decide constitutional issues. I think there's some Supreme Court some language in the Supreme Court's decision saying that's not necessarily a mandatory rule, that agencies can't get into constitutional issues as a matter of agency expertise. And, a couple of examples just quickly would be the Supreme Court's Thunder Basin decision, where they said the Mine Commission there had some expertise that it could bring to bear on the issue. And there's another Supreme Court decision called Risica, which is not cited all that frequently, but it too is a decision where the Supreme Court found that an agency had expertise in the milk industry that it could bring to bear on the case there.
And I think when we're thinking about these and thinking about those opinions, I believe you mentioned also in your paper or in our discussion that we're waiting actually for a commission opinion in the Raymond J. Lucia case, and we're actually waiting to hear what the dissent says, and that might be critical in these future suits, right?
It will probably be something that the respondents in the district court cases and now the appellate cases in several circuits will bring up possibly as supplemental authorities. And you are right. We do have a decision from the commissioners in Raymond J. Lucia companies, and also in another case called Timbervest. In both of those instances, the commissioner, a majority of the commissioners, said that they didn't see much of an Article 2 issue here. They persist in considering their ALJs to be employees and not inferior officers, which brings me to kind of the merits issues here, which is the Article 2 issue. In general, what Free Enterprise held was that this dual for-cause removal provisions in the law in general would be constitutionally infirm, at least as they were constructed in that case. The challengers against the SEC, of course, argue that the SEC commissioners and the ALJs, because of the way they're appointed through the Office of Personnel Management and through the role of the Merit Service Protection Board, are actually enjoying too many layers of good cause removal in violation of Article 2 of the Constitution. But really what the issue comes down to in these cases is whether the ALJs are officers or employees. As I mentioned in the two commission opinions that we have very recently, a majority of the commissioners said they were employees. We do have a couple of cases, one from the Supreme Court and one from the D.C. Circuit, which attempt to shed some light on this, although I'm not sure how much light they shed. They may just make things a little bit more confusing for folks.
Let's look at two of those cases, I guess. It's the Landry case and the Freitag case. Sure.
The challengers, I'll start with them. They like the Freitag case. This is, I want to say it's from the early 90s, I believe, involving one of the tax reform acts that gave the chief judge of the U.S. Tax Court power to assign certain cases to what are called special trial judges. In one set of cases, the special trial judges had some finality over what were basically small dollar cases, and there was another much broader category of cases where they were not final, but the chief tax judge nevertheless had authority to assign those matters to them, subject to an internal standard of review. And in Freitag, the Supreme Court said, that these special trial judges were inferior officers subject to the Appointments Clause in Article 2 of the Constitution because they exercised enough discretion and finality that they couldn't be considered mere employees, that there was more going on here. In the D.C. Circuit's Landry decision, by contrast, the panel there held that the Federal Deposit Insurance Corporation's administrative law judges were employees and not inferior officers. But even the majority in the Landry case, which is heavily relied on by the SEC, acknowledged some issues with the Freitag case in terms of understanding what role finality actually played in that case, because the irony of Freitag is that the taxpayer there had challenged the exercise of this other case's power by the special trial judge, rather than the three specific powers the STJs had that were actually final. So the question of finality is still kind of an open question. The Supreme Court did say in Freitag that, or at least strongly implied that, if the special trial judges were final for one thing, they were likely final for the other thing as well, and that probably played a significant role in the outcome of that case. Also in the D.C. Circuit's Landry case, there was a concurring opinion where I believe it was Judge Randolph agreed with the result because there wouldn't be any prejudice to the bank executive who was subject to a sanction that was being upheld, but he also went on to talk about how the majority in Landry kind of went a little bit too far in its effort to distinguish Freitag by not acknowledging the alternative holding in Freitag, which was that even if the special trial judges had lesser duties, they might still be inferior officers, and that the majority may have overemphasized the role or underemphasized the role of the internal review standard that applied to the special trial judges. So there still remains, quite a lot of confusion, I think, about, the role of finality, but certainly the SEC, believes its ALJs are non-final because they only issue recommendations called initial decisions, which the commission then either on the petition of a respondent or on its own motion can take up and review de novo. And even in cases where there isn't where the commission isn't asked to review an initial decision, they will still issue an order of finality saying that decision is now final.
And Mark, I think that's kind of dovetails also into what I would consider almost an obvious issue or an obvious point to bring up, and that would be almost this home court advantage. And I know that the SEC Inspector General issued a report saying, look, there's no evidence of bias, but take us through that. What is happening with these bias allegations?
Yeah, it's I think some of them are more generalized. Some of the parties challenging the SEC's ALJs and their complaints is cited a New York Times article from a few years ago, just raising more generalized concerns about the use by federal agencies of their so-called in-house courts. Some more recent allegations appeared in a Wall Street Journal article that alleged recited allegations by a former SEC ALJ that she felt pressured by the chief administrative law judge to rule in favor of the agency's enforcement division. And of course these articles from both the New York Times and Wall Street Journal have found their way into almost all of the 10 cases challenging the SEC in one way or another. Interestingly, the commission itself addressed the bias issue in its Timbervest opinion just a few weeks ago. Essentially, the commissioner said that we don't see any bias in that case, and kind of played down the role that much older allegations from the Wall Street Journal article might have had. Just saying that they really weren't connected to the Timbervest matter. But the agency's Inspector General has taken the allegations seriously, and recently did issue an interim report, as you mentioned, finding at least at this stage of the investigation no evidence of a bias. Although the report did note that the one ALJ that had been singled out in Timbervest had declined an invitation from the commissioners to provide an affidavit to them stating his views on the matter. But of course it's an important issue. It does go to the fairness of the SEC's administrative process, and I think we'll see more about it eventually from the SEC's OI Inspector General. But when that will occur,
Yeah.
it's hard to say because it's still an ongoing investigation.
Right, and I think at the beginning when we were talking about, some of the most current issues, we were talking about, the Commission's proposals on those changes, changes in the proceedings, trying to help this issue. And then one other thing I think is very interesting is we have, as far as remedies go, Judge May in Georgia proposing kind of a solution or a solution of sorts.
Right. Yeah, Judge May in two of the cases that she's had, and I think maybe she's had more of these SEC ALJ cases than any other district judge so far. But one of the points she had was that the commission could maybe solve its ALJ problem just by appointing its own administrative law judges. There may be some practical concerns about that. Some commentators have suggested that the SEC might be concerned about the retroactivity of that type of action on older cases. There may be some practical concerns, as Justice Breyer raised in his dissent in Free Enterprise. Things like what exactly is the status of ALJs under the Constitution? Is this something the agencies can fix? Does Congress need to get involved? Could the President issue an executive order that solves this? What kind of remedy could the courts come up with? I might point out in Free Enterprise, the court there actually did come up with a kind of an elegant remedy. Some could say judicial sleight of hand, but perhaps kind of elegant in just declaring that the SEC could fire the PCAOB board members at will, thereby removing the too many for-cause removal layers and reducing it to just one so that the president can more effectively and faithfully execute the laws. So I think there are a lot of open questions about what the remedy will be, and we'll just have to wait and see what the Second and 11th Circuits have to say, because they do have several of these SEC ALJ cases pending before them.
And so I know we'll obviously follow all of that to see, are there any new potential remedies, what's the Commission proposing, and what else are we going to follow? What else should someone be following if they're interested in this issue?
Sure. Well, first and foremost, of course, we should be following, I think how the 11th and Second Circuits approach these cases when they do issue opinions. I think the briefing is mostly complete in all of the cases. I know we had oral argument just recently in Lynn Tilton's case in the Second Circuit. I think it'll be interesting to watch these appeals for a couple of reasons. One is to see just how influential the Seventh Circuit's Bebo decision is. It seemed to have some influence on the D.C. Circuit in yesterday's Jarkessi decision, and I would expect both of those decisions to factor into whatever the panels in the Second and 11th Circuits decide. Another thing to look at is just how the Second and 11th Circuits apply their own precedents, because they both have some older cases, and in the case of the 11th Circuit, a case from January of this year that pretty strongly suggests that they would prefer to channel cases through the agency. So I think the challengers to the SEC may have somewhat of an up-road battle in those two circuits. But again, we'll have to wait and see what one or more of the panels decide. Another thing to watch for is just to look for the public comments on the SEC's proposals to expand some of the protections afforded to respondents in administrative proceedings, and how the electronic filings revisions to its rules of practice might play out. I don't know what the time frame for those rules becoming final will be. We should have comments, I think, probably before year's end, and when the Commission acts on them after that, it would be hard to predict. But I would say those are the main things to look for going forward.
Perfect. And Dan, I know I see my question beeping. Do we have questions from the attendees?
Nope. I know we're pretty much at the end of time, but I think we answered the question that came in, so I think we're good.
Okay. All right, sounds good. So let's see. I have one. I think you already mentioned it. Given the scope of the SEC's review of the ALJ, what final decisions do they make?
I'm sorry, you were breaking up a little bit there, and I didn't quite catch the question.
I said, given the scope of the SEC's review of the ALJs, what final decisions do they make?
If I'm not quite sure I understood the question because my phone line was actually breaking up as you were reading it, Jenna. But I think if what you were asking is how are what is the role of finality at the SEC? The administrative law judges at the SEC make what are called initial decisions after conducting usually a several weeks long hearing where they'll issue some orders about what evidence can come in and things like that, and then they'll issue one of these initial decisions eventually. If a party loses before the ALJ, they can petition the commissioners to review the initial decision, and then the commissioners would take a fresh look at it, de novo, meaning from the beginning. If they then lost before the commission, they could, under the SEC's channeling statute, then petition for review in one of the federal appeals courts.
Okay. I think Jenna's audio, we may have a trouble with her audio connection, but I hope that answers the question. I'm trying to see if there's any other chat questions. This is Dan. But I don't think there are any others. Jenna, I think your audio is still probably out. I think so. So anyway, I just want to thank everybody for participating. Thank you, Mark, for presenting today.
Thank you, Dan, and thank you, everyone on the line. I really enjoy speaking with you today.
If you have any questions as a follow-up to the webinar, please you see Jenna's email on hopefully you're seeing it on the screen now, jenniferellis@wolterskluwer.com. And of course, if there's any kind of additional direction we can give you as far as finding the resources, please let us know either by contacting Jenna or, of course, we have our legal training link on the screen as well. And again, any questions or follow-up, please let us know. We'll also be sending out the copy of the slides as well as a very, very brief survey request. Just asking you to fill it out. It takes less than 2 or 3 minutes. Typically, we get terrific feedback, and it's exceptionally helpful to us. It's generally only about 3 questions, but if you have the time when we send that link out, we would greatly appreciate it. And once again, thank you all for participating, and we look forward to you on the next webinar. Thanks again. Bye-bye.